Hello, dear fellow panelists and dear participants, and welcome to our second 2023 Insight webinar series of the DRBF Region 2, Together the World Forum Offshore Wind. Dispute avoidance on multiple contract projects in the offshore wind industry, reducing costs and cost escalation on offshore wind projects. Today, we will be discussing the importance of aligning contractual provisions and requirements. We would look at risk allocation alternatives on multi-contract projects within the wind farm marshalling contracts. We'll also have a look at legal and other constraints and DB arrangements on multiple contract projects. I am Georgiana Tekuc, President-elect of the DRBF Board Region 2, and I am your host for today. For those of you who are new to DRBF, the Dispute Resolution Board Foundation was established in 1996 by the creators of the dispute board process with a mission to develop dispute avoidance and effective resolution for construction projects. Today, the association has about 1,400 members in over 70 countries. And the dispute board process has expanded worldwide and is now used on a variety of projects and long-term contracts of many types and sizes. The DRBF develops best practices and offers training and educational resources for project owners, contractors, and DB practitioners. And it partners with other industry organizations to adapt the DB process to new sectors like offshore wind. It may be of interest to note that DRBF is publishing a guide to best practices and procedures, the Dispute Board Manual. Our partner, the World Forum Offshore Wind, is the world's only organization 100% focused on promoting offshore wind energy on a global scale. It is based in Hamburg, Germany, but has also offices in Tokyo, Taipei, and New York. Its membership represents the complete offshore wind value chain, including utility companies, manufacturers, service firms, as well as other nonprofit organizations. WFO's unique global profile facilitates access to governmental and international forums in order to open new offshore wind markets and to advocate for global offshore wind growth. And now let me introduce you our speakers of today, and we'll start in the order of them speaking with Dr. Nicoletta Kruger. Nicoletta is a German qualified lawyer with more than 20 years of experience. She is a partner of Hamburg-based law firm Corvel. She advises her national and international clients in contract negotiations and represents them as counsel in dispute adjudication proceedings, arbitration, and state court litigation. She's also regularly appointed as an arbitrator, for example, in ICC, DIS, GMAA proceedings and proceedings under other arbitration rules. The focus of her practice is on national and international construction projects, in particular in the renewable energy market, including particularly the offshore wind industry, maritime industry, and general plant construction. Nicoletta is the vice president of the German Maritime Arbitration Association and currently co-leads a practice group on settlement facilitation at the German Institute of Arbitration. Tobias, since his admission to the bar in Germany more than 20 years ago, Tobias has been a competent lawyer who has accompanied complex engineering and construction projects worldwide in the areas of infrastructure, energy generation, mobility, and process engineering. Tobias heads the working group on international construction law of the German Lawyers Association and is also the chairman of the Offshore Dispute Resolution Committee of the World Forum Offshore Wind. Marcia Vieira Royal is a solicitor of England and Wales and a lawyer admitted to practice in 2 other countries with a background in both civil and common law systems and an LLM degree. Benefiting from more than 20 years of solid legal advisory experience in Sao Paulo, New York, and London, particularly in the energy industry and shipping, such as ship finance, shipbuilding, bareboat charters and charter parties, vessel sale and purchase. She has, in recent years, relocated to Germany, where she assists clients as contract and claim manager. She's advising them on wind energy projects in Europe, Asia, and the Middle East, negotiating FIDIC contracts, offshore vessel charter parties, refits contracts with shipyards, and also preparing DAB proceedings. Marcia is a member of the London Shipping Law Centre and is working towards membership of the Institute of Chartered Shipbrokers in London. They will be joined today by our colleagues from DRBF, the country representative for Germany, Sebastian Hawke, and the country representative for Ireland, Gerard Monaghan. Sebastian is a lawyer by profession, a fellow of the Botswana Institute of Arbitrators, a FIDIC certified adjudicator, and a FIDIC trainer with more than 30 years experience across the construction industry. He has experience in onshore and offshore energy projects worldwide and provides consultancy, dispute resolution, auditing, and expert witness services to energy project stakeholders who find themselves involved in disputes. Sebastian has experience of dispute resolution across multiple jurisdictions and project types. His primary focus is on plant, nuclear power, grid, and onshore and offshore wind projects. Gerard is a chartered engineer with some 30 years experience in the delivery of major construction projects in Ireland and internationally, with a particular focus on energy and renewables. He's an experienced ADR professional and is appointed regularly as arbitrator, adjudicator, mediator, conciliator, and dispute board member. Gerard is a chartered arbitrator and fellow at the Chartered Institute of Arbitrators, a CEDR accredited mediator, and a member of Engineers Ireland arbitration, conciliation, and adjudication panels. He's also a FIDIC certified adjudicator and a member of the FIDIC President list of approved dispute adjudicators, and a member of the Ministry's panel of adjudicators in Ireland, established in accordance with the provisions of the Irish Contract Acts of 2013. And last but not least, my colleague moderator, Nicholas Rigby. Nick is a chartered engineer and fellow of the Energy Institute and has more than 35 years across the energy industry. He started NRG Management Consultancy to provide contract management and expert witness services to energy companies who find themselves involved in disputes. Nick has experience of dispute resolution across multiple jurisdictions and project types. Prior to starting NRG, Nick was head of contract management at Low Carbon Contracts, dispute director, and head of strategy at RWE Energy. His primary focus is on grid and offshore wind projects, and he's also the co-chair of the DRBF Offshore Wind Task Force. So thank you all for joining us today, and I will ask now Nicoletta to get us started. Nicoletta, if you please.
Thank you, Georgiana, for the kind introduction and for the invitation to this very interesting panel, actually. In the next minutes, which I have for my presentation, I will focus on a very early stage of multi-party offshore wind projects, namely the contract drafting stage. In this respect, I would like to draw your attention to two particular points with regard to dispute boards that should be considered already at that early stage. Why is it important to think about dispute board proceedings as early as in the drafting stage? Because dispute board proceedings are always based on contractual agreements, with the exception of very few jurisdictions, such as UK, dispute board proceedings are not regulated and not provided for by law. Therefore, everything with regard to dispute board proceeding needs to be agreed contractually. But, as you probably all know, experience shows that should there be a disagreement or should a dispute have arisen already, it is really difficult to bring all parties together and to agree on legal proceedings and even on details of the legal proceedings. Also, at that stage, time is often of the essence, and lengthy negotiations on details of procedures, how they should be set up, etc., are often really not helpful at that stage. Now, what are the 2 points I would like to focus on? The first point I want to make is that the parties, very basic actually, need to consider if, and if so, for what particular situations they would like to provide for dispute board proceedings in their contracts. The second point I would like to address is the need to align the contracts entered into by the different parties to the project if it is decided actually that there should be dispute board proceedings. So regarding the first point, there is no ideal dispute resolution mechanism. This doesn't only apply to dispute board proceedings, but to all proceedings, including arbitration, mediation, etc. What is the best dispute resolution mechanism is to be evaluated according to the situation or situations which may arise later on in the particular contract situation. Let me give you an example of different situations. Dispute board proceedings can be agreed for the period in which the project is in this execution phase, i.e. in the construction. Likewise, however, contracts can also stipulate that dispute board proceedings should precede any dispute resolution procedure at any stage of the proceeding. The latter case would not be limited to the construction phase, but dispute board proceedings would then need to be initiated before any other legal proceedings can be initiated. For example, also after taking over and acceptance of the works of the project. However, the phases of a contract differ substantially. In the execution phase, time and avoidance of delays are essential, actually. If one trade is delayed, it is likely that other trades will also be delayed due to that. In the case of offshore wind projects, this is compounded by the fact that different seasons of the year have significant or can have significant impact on the abilities to carry out works. There may be too high waves to work. There may be ice in the harbor in the winter times, making works not possible or possible only to a limited extent. There may be too much wind, etc., etc. So if the project is delayed into an adverse weather window due to the delay of one trade, this leads to additional delays, and then the project may, as a whole, fall behind schedule with the risk of serious financial damage, recourse claims, and lengthy disputes associated with it about responsibilities, liabilities, etc., you name it. Therefore, it may be advisable to provide for a rapid dispute resolution mechanism for the execution phase of the contract. And dispute board proceedings can be a quite good dispute resolution mechanism for this purpose, actually. It is designed to avoid, or at least preliminary resolve, disputes within a short period of time. Now, if the project is already in, for example, the warranty phase, the time factor is often no longer as relevant. The disputes in this warranty phase are different. They are often related to defects, liabilities, financial claims for alleged variations of the contract due to delays from the execution phase, etc., etc. So usually there is no particular urgency to solve or decide on these disputes. Moreover, the parties in this stage may be more interested in conducting proceedings in which all points of dispute can be discussed in detail and in their entirety, i.e., to get neutral expert opinions, etc., etc. However, this leads to a longer duration of the proceeding than is envisaged for dispute board proceedings. Due to the brevity of the dispute board proceedings, it will simply not be possible to evaluate all aspects, legal aspects and technical aspects in all detail and depth. So therefore, for the warranty phase or for such situations, for example, arbitration proceedings may be more suitable. And coming back to my starting point, it should be already decided in the contract drafting stage whether, and if so, for what situation dispute board proceedings can be helpful to the parties to this particular contract. Regarding my second point, the alignment of contract clauses. If the parties, or usually in particular the employer, decides to provide for dispute board proceedings, at least for certain situations, and if dispute board proceedings may involve more than one party, in particular in multi-party contract situations and projects, the various contracts must be aligned accordingly. Why is that? Because a clause on dispute board proceedings is only valid among the parties of this particular contract, i.e., for example, between the employer and the one contractor. It's not possible usually to join in a third party or other further parties as well, unless, of course, at this later stage, there is an agreement of all parties, the employer, the contractor, and the party or parties who should be joined into the proceeding on this fact and on the procedural details. But as I said before, experience show it will be quite difficult to find the willingness and agreement on all the details and on such joinder at such late stage. Therefore, the parties should take particular care already in the contract drafting stage to ensure that identical dispute board proceeding clauses are included in all contracts. What do I mean with all contracts? It's not only one contract between employer and one contractor, but the contracts between the employer and all its contractors, plus the contracts of the contractors and the subcontractors as well. The dispute board clauses should also provide then for a third-party joinder, that such third-party joinder is possible if multi-party proceedings are to be possible among the different parties of the project. A multi-party proceeding can be useful, actually. It's not necessarily useful, but can be useful. For example, just to give you one example, if the responsibility for an interface is in dispute. In such a case, a dispute resolution between the employer and one of its contractors alone may not provide a final or satisfactory solution. Similarly, all dispute board clauses must provide a procedure for the appointment of the dispute board members, or so-called adjudicators, in the event of a multi-party proceeding. Why is that? In the regular case of a proceeding between only two parties, each party appoints one of the dispute board members, and the two dispute board members then appoint the chairperson. However, if more than one party initiates dispute board proceedings, or if one party initiates a proceeding but against more than one respondent, then it must be stipulated how the multi-party side jointly appoints one dispute board member. Further, all dispute board clauses must provide for the same procedure, the same procedural deadlines, for example, with regard to the appointment of the party-appointed adjudicator, for example, with regard to the length of the proceeding until recommendation is rendered or decision is rendered by the dispute board. Because if there are different clauses in different contractual situations, then there is uncertainty what is valid, how it should work out, the proceeding, et cetera, and we all know uncertainty always leads to further discussions and possible delays in a proceeding, which is not useful if time is of the essence, for example, as mentioned in the very first stage in the execution phase. Overall, the above are examples, and I'm pretty sure that my fellow panelists will give you more examples later on the challenges of multi-party dispute proceedings. One more comment, the alignment of contract provisions should not be limited to dispute board clauses, actually. But further thoughts should be given to whether, and if so, which other contract clauses should also be aligned in multi-party projects to enable or at least facilitate dispute board proceedings. This may be with regard to interfaces, with completion dates, with regard to warranty periods, et cetera. Just to give you one example before I come to the end, if the responsibility of two contractors for the same interface are regulated differently or not at all in a contract, this may lead to a situation in which a dispute board proceeding can offer no solution or only with difficulties. Because if the interface responsibility is not contractually agreed, a dispute board in most cases does not have the competence to fill in this gap. At best, the dispute boards can propose a reasonable preliminary solution. However, to take a decision needs a contractual basis, and if there is no, there will perhaps be no decision taking by the dispute board. Now, I think I've consumed my time, and with these rather general thoughts, I would like to stop here. Thank you for your attendance and attention, and give the floor to, I think, Marcia and Tobias. Thank you.
Good afternoon. It's a pleasure to be in this panel. Thank you for having me. I'm coming with an illustration at subcontract level of what my my very admired colleague just explained, Nicoletta. We are looking at a situation. Let me just pull out these slides here and share it with you. So we are coming with a situation here. Let me see. Where, going back, we have nowadays these marshalling arrangements where basically we're going to have an arrangement between contractor and employer, the owner of the future wind farm, whereby we're going to transfer all material and equipment to an area where it shall be, or this material and equipment shall be stored for consolidation. So this can actually be done at the level of different, of course, components and types of supplies. Normally it's components, and normally or very often it's about material that is which manufacturer is actually requested, customized for this particular project. In our case study, we have 3 different streams, and I picked up one which I thought, and Tobias as well, that seemed to be the most complex one, the one in the middle here. So in this particular situation, the same special contract that we chose here involves components manufactured outside the EU, in a country that if it wasn't for Brexit, it would still be in the EU, but anyway, won't say the name. Contractor signs such subcontract with a terminal. So here is the situation. Then we have here contractor signing a contract with the terminal to actually pick up, and I'll move to the next slide, pick up or transport these components from the manufacturer facility outside the EU, and organized, basically organized, take charge of everything that's going to happen with these components until installation phase, until installation site. What does that entail in this particular example? First of all, is the chosen transportation means is through barges, which is very common in this industry. So basically, the barges live here at the port of the manufacturer, and right up front there is a harbor acceptance test being conducted by the employer who commissioned out this manufacturing here at this level. The employer, and the employer then, if satisfied with what he sees in terms of the end product of the manufacturing commissioned to this company here, issues a report, which is in the case essential, issues a report of pre-acceptance, pre-technical acceptance. This report will be essential for a contractor to perform one of its initial obligations under this arrangement. But basically, the whole issue here is that contractor is actually commissioning out under this subcontract structuring, this marshalling structuring, to a terminal, different actions using the equipment of the terminal, such as cranes, axle lines, riggers, low space in its facilities, loading areas specifically for that particular component, which should be dedicated, should be special, and transport within the terminal until as such other places as it is necessary, such as the final storage place before we reach the installation phase, and provide personnel and the services to do this. And that's basically what the contractor relationship with the terminal entails. And that's a subcontracting level from the contractor job. First of all, there was a contract between employer and contractor for, of course, the building of this wind farm. And then contractor hires this terminal and enters this contract, and whereby terminal will be handling quite a lot of this work here. So in this case here, we have the barges arriving at with these components at the recipient terminal, which is within the EU in a quite famous and huge port. And within this terminal, first of all, and first and foremost, contractor conducts a specific test, which is a barge test, to verify whether the components received match the report issued by employer when these manufactured goods were leaving the sending the remittance of these components there where it were manufactured. So here, before they actually offload it from the barge, they conduct this verification. At this stage, if there is already a delay, and that's where the illustration of what Nicoletta was saying kicks in, if there is a delay here in conducting this test, then we already have implications. We already have potential situations in preparation or with a domino effect towards the next obligation. And the next obligation, assuming that the barge test reviews everything is fine, is actually for terminal on behalf of this contractor to offload all these components from these barges after having proceeded to the inspection, and arranges it in the quay side of this terminal in such a way as it has been already determined under this contract, and then proceeds to loosen the sea fasteners and rearranging these components. Well, we have here in this phase that is called loading already a situation that if this operation here gets delayed for reasons within the sphere of control of the terminal, then the terminal is already liable to pay liquidated damages under this contract, okay, for mere delay. But notice that before that, many other things had to happen. Yeah, tests here, tests there, offloading in a certain way, the loading, which is a rearrangement of these components on quay side. Lots of things have to happen in specifically described ways. But this has to be taken place according to schedule. Otherwise, the terminal is already liable. Also, there is another point of very much importance here. As this offload takes place, this offload takes place, but only then, after the inspection in the barge took place, we can talk about care and custody being passed from contractor, because until here it was under contractor's sphere of control, passing to terminal. Now, whilst unlashing the sea fasteners and loading in and rearranging these components at quayside, if the terminal notices that there have been damages to the components, it can turn to the contractor, discuss this, and then one of them, they can actually choose who's going to do it. In fact, if it's the fault within the sphere of influence and probably the fault of the terminal personnel, terminal would actually volunteer to do this or arrange for them to actually be the ones undertaking responsibility for these repairs. But then they are authorized to do repairs to minimize the damage. However, if this is simply noticed by the terminal personnel and probably occurred here and did pass this inspection in the barge inadvertently, then terminal can also discuss with contractor, and contractor instead of the terminal will actually be chiefing or carrying out, being responsible for these repair works. You can imagine by this phase already how much there is in terms of potential for this contract go wrong. Yeah. So you talk about what Nicoletta was describing about an entering potential ADR arrangement. That's the type of contract where parties would largely benefit from this sort of clause establishing some sort of entering dispute resolution, and I would expect here to be a DAB procedure, whereby at least between phases, there should be a quick resolution of disputes so the next phase doesn't get so delayed. Even if there is some delay, there will be consequences, but then the adverse consequences to the parties can be minimized. Talking about these adverse consequences, we are talking here under this contract, so talking about liquidated damage. But in fact, under this specific contract, if the terminal delays its obligations, the carrying out of its obligations phase through phase, contractor has also the right to withhold payment. And that's the bit that really hurts, because the way this terminal actually factors in or computes the amounts owed to it in terms of invoicing includes, of course, not only equipment, but the kind of equipment that will expire by using only that situation, hours operating a crane, etc., but also hours of its personnel, which is actually computed through timesheets. So you have all this whole set of costs undertaken by terminal, and then they get here and they present their invoice and they can't get paid because they have been delayed. And then they have to discuss whether these delays happened through because of issues that were within their sphere of influence, as the contract calls, or not. So that means you have to actually pass through a situation where we're going to verify whose fault it was. It doesn't help in this case that we are under one civil law regime here, which is quite strict, and whereby, as normally it is the case in the civil law environments, you have the issue about the party at fault is one of key relevance.
Do you want to draw your remarks to a close, Marcia?
I have also here then a next phase, which is the final phase, which is the final stage that the terminal has to actually transport to the final storage place. So these are all the phases here that we discussed mostly on the back of the previous illustration. And then basically what we have here as a takeaway from this illustration is that the right to withhold payment and the obligation to pay liquidated damages are relevant ones. One particular issue of importance here is that normally this manufacturing and delivery of components is made in batches. It's a staggered delivery. There is never one transaction. So at the end of the day, what happens is that this situation where these delays and problems may occur will repeat themselves up. So then again here, that is the two thoughts were actually provided here in the sense of whether we could use ADR as an interim remedy. there is an issue here. If the parties would accept, then we move to the next. But what if the party feels that it would be jeopardizing in its rights, and this will be too much of relevance, financially speaking, to leave it like this just for the sake of progressing? Parties can actually change their mind and manipulate these and change, and this may not be the ideal remedy. And at the end, in fact, the other takeaway message is that no party can actually remove or subtract from the other the possibility of going to arbitration. And I pass the word to
quick final remark, conscious of time, of course. So we draw out this example on the very bottom line of supply chain, just to demonstrate what's happening there in terms of relevance for dispute. So it's in the marshalling harbor, very low in the food chain, but due to the pressure on the business cases in the offshore market, the defragmentation of contracts, of multi contracting models, that expands massively. And you see here foundation lot split up in 3 contracts: monopiles, TPs, and installation, and that leads to much more necessity to accompany in dispute avoidance mechanisms. I hope that illustrated well. So thank you, and we pass on.
Sebastian, if you're ready, please. Until Sebastian gets to share his screen, just to let you know that we could go past the hour if anyone wishes to stay on. Thank you.
Thank you, Georgiana. I hope I am now on. Thank you all, to all of my pre-speakers, and warm thank you for the excellent speeches. Hopefully it works now. Yeah, it does. So we are basically having in the title the idea of multi-party dispute resolution on a level which some would believe it's a lower level of dispute resolution. Some believe it's the level, but it's another story. So we do have basically in this type of arrangement and setting 2 parties in the DAB. On top of a person who is typically involved in making determinations and doing other things. We do have a binding instrument called contract in between those. And this contract confers the power upon the DAB to solve disputes, whether doing that in terms of dispute avoidance or giving decisions, does not matter now. So we do have this idea of a 2-party approach, basically, because there is one contract. But if you like to extend it, then you will have to look at solutions. That's what my other speakers already have pointed out. So I can follow up, because we do need always a power of a DAB to settle disputes, whether by means of dispute avoidance or otherwise. The core points, to some extent from my perspective, is that we do have timelines to look at, because decision making particularly is does also mean to abide by constraints, to comply with constraints. As the same applies to some extent, particularly under FIDIC 2017. You do not have endless time to avoid disputes because things must go on. Diversity of parties and confidentiality may be a big topic. Because you do have a multi-party approach, which does not always fit with confidentiality. The DAB has basically no authority to travel beyond its own jurisdiction or its own type of terms of reference, typically dictated by a dispute adjudication agreement. The DB has no authority to set out procedural rules for other disputes. So you cannot suddenly come up by a 2-party agreement requiring a DAB to do something. Rather, you would have to involve the DAB as well, because otherwise it doesn't work. You cannot just come across and tell them, DAB, when you are now doing some services also for our benefit, that would require a tripartite agreement. The privity of contract principles, so there is a problem. The pros and the cons to some extent are here. We would like to have from time to time this type of multi-party dispute resolution approach, because there's a lot of speed probably, which is helpful. We can reduce early legal risk which is involved in disputes, of course, all the time. A single set of multi-party arbitration will usually be in the interest of the contractor, who will otherwise need to bring a separate claim against the subcontractor. So from the contractor side, there's always a kind of view that also there's a kind of cost saving if they can bind the subcontractors by multi-party agreements. Some cons: the employer will generally have little interest in participating in multi-party arbitration if we talk about subcontracting, because well, the employer might have an interest that subcontractors are getting paid properly from time to time, but not always. So this is a special problem. So we will have typically 2 contracts in place, and we will have then to do the arrangements which help us to overcome the problem of privity of contract, because we do have the same scenario here and there. We will have also to tackle the problem of dispute resolution if it is not dispute avoidance, basically, because we do have a starting point and an end point under FIDIC, because the DAB has 84 days within which it may give a decision, and you cannot just harmonize it easily. That would require much more wording than simply a kind of idea. So a referral, rebuttal, hearing, DAB decision, notification, all of this would have to be harmonized for the purposes of 2 different contracts, 2 different projects, in a way, or ideas or concepts, though it might be a major project, but different purposes under each contract. The diversity of confidentiality and the conversity and confidentiality problem is something to be tackled anyway, of course. You might have confidentiality problems in terms of prices, for instance, in terms of design, know-how, etc. That's not easy to overcome. FIDIC forms of contract do not yet provide for comprehensive solutions, though we have had in the past, in the 1994 FIDIC subcontract, a kind of idea. You find this particular information here in the slides. I don't like to read it to you, but at the time you see here on the right-hand side, there was a kind of sophisticated guidance on how to tackle multi-party adjudication in the event of subcontracting. So it might be good to look at the old FIDIC subcontractor. The new one has a different approach, but also there, of course, you find a very sophisticated solution on how to involve a second party. Jurisdiction, it's usually a kind of problem insofar as it is a condition precedent of arbitration. So you do need it, but you don't like it, but you need to go for it. That might be sometimes another problem. If you like to go for multi-party solutions, and you need to look at particular solutions in terms of also arbitration as an umbrella, because you may have multi-party adjudication, but you can't do that easily if you don't have also multi-party arbitration on top of it, which would require you to look at these rules on top. So you might wish to look at subcontracts. The main contract and the subcontract for construction will typically remain 2 distinct and separate contracts. And for dispute resolution purposes, you might wish to integrate things in a way, but that is, as you have said, not a common cause, and there's no proper common solution yet available for that. My title was to some extent to look quickly at legal constraints. You see here the privity of contract doctrine make things complicated. Consent of all who are involved is required. Please also think about the DABs who must be ready to do that. Confidentiality is an issue. Laws do not generally allow for multi-party adjudication, and some legal maxims may help to involve other parties in a way. There is special arbitration papers available. I've put that at the back, and you may wish to read that. There is a number of experience available already. So here we have some particular ideas about how to involve other parties based on particular maxims, which I don't now need to read to you, because you can do that easily and would take much time to go into such details anyway. So compilation of legal constraints and challenges. DRB has no authority to travel beyond jurisdiction. I've mentioned that. The DRB has no authority to expand the scope easily just for convenience. DRB has no authority to set out procedural rules for other disputes. Also, this is a problem. The privity of contract in general, of course, will have to be considered. And the freedom of contract requires consent, again, of everybody. For those who are really interested in multi-party dispute resolution, you might wish to look at these 3 small papers and books. But there's much more available if you like to do that. Thank you very much for the time being, and we will be, of course, all ready to give answers to possible questions. Thank you.
Thank you, Sebastian. Jerry, are you ready?
Yes, I am. You're going to share the slides, Georgiana. Can I control them myself?
Yes, please.
Which you control them, will you?
You want me to do it for you?
No, I could do them myself. But somebody's sharing at the moment, and it's not me. Maybe it's Sebastian.
Sebastian is
It's there.
listening.
If you like to take it over, please.
Yeah, if you stop sharing, I'll take it over.
Shall I stop mine?
Yes,
Please.
please.
Okay.
Thank you, Sebastian, and good afternoon all from a warm and sunny Dublin. I want to start by thanking my fellow panelists for the contributions to date, which have been very, very informative. So what I want to do for the next 5 or 10 minutes is to reflect on what it is we've learned so far this afternoon from our fellow speakers, look at the opportunities and challenges in terms of dispute avoidance via DABs and multi-contract DABs, and get into some more granular level as to how they might work, notwithstanding the various constraints. So I think you can see the screen at the moment. You can. My slides are sharing, Georgiana, correct? So we've heard today already from Nicoletta about the legal dimensions, the legal challenges, the need for clauses to be aligned, and the difficulties with dispute avoidance around interfaces. Marcia and Tobias have set out very, very, very eloquently the kind of complexity of the projects that dispute boards typically face, and complexity of offshore wind projects and the various interlinking dimensions and the liabilities that arise from it, and the complexity generally. Sebastian has very comprehensively set out the constraints, effectively legal constraints of privity of contract, jurisdiction, scope, etc., that DABs operating on offshore wind need to be aware of, and those who draft the contract provisions and the project owners need to be aware of it. But notwithstanding all of that, I think the opportunity does exist for multiple contract DAB solutions. I mean, we all know the challenges of DAB projects. They're complex, they're difficult, they're offshore. There's generally complex contractual arrangements, typically 4 or 5 contractors rather than a single EPC, as you can see on the slide. Challenging environment, you're offshore, structures difficult to access, maritime issues, grid connections. Currently, there are no specific industry-specific contractual mechanisms for providing an effective DB process for offshore wind. The industry recognizes or introduces new stakeholders. There's maritime issues, there's shipping, there's vessels, there's grid connections, a range of stakeholder constraints that mightn't be normally present on an infrastructure project. And these stakeholders or influences are not typically catered for in your standard contract forms such as FIDIC. Such forms are not typically drafted specifically for heavily equipment loaded projects comprising vessels, cranes, special purpose vehicles, remotely operated vehicles, etc. And in addition to the law underpinning the contract, there's oftentimes inevitably maritime law issues to deal with. So really, where are the potential dispute flashpoints? You have new technologies and standards. You have sequencing of major operations, and Marcia spoke about this at length. The supply chain. If one dimension or one element of the supply chain is delayed, it can have very, very serious knock-on effects and consequences on the next stage. And the costs are significant, particularly in terms of vessel hire. We've heard previously that depending on the size of the offshore wind units themselves or farms, that vessel hire can typically be of the order of 400,000 to 500,000 euros per day, which are very, very significant sums. So delays in terms of vessel hire, in terms of offloading or otherwise, or turbines not been ready, kind of a massive impact and a massive cost. Integration of onshore and offshore elements and transmission system interfaces, to name but a few. So really what I'm pointing to is that interface issues, and Nicoletta mentioned this earlier, interface issues are critical. It's really the interfaces between different contracts, different suppliers, different systems. It's where the disputes tend to arise. And it's where the activity really is in terms of dispute avoidance. So any system that you might install needs to be cognizant of that and need to be capable of operating at interfaces. And this is something again that Nicoletta pointed to in terms of constraints. Just in terms of a very quick summary of what a DAB does or about. I mean, this is the FIDIC DAB procedure rules from 2017, and Rule 1 summarizes both the objectives and the benefits of a dispute board. Objective 1 is to facilitate the avoidance of disputes that might otherwise arise between the parties, and 2, to achieve the expeditious, efficient, and cost-effective resolution of any dispute that arises between the parties. So there are real benefits to a project owner. If you're a project funder or owner of an offshore wind installation, what you want is you want to get the project built quickly and efficiently and get it generating electricity so you get a return on your investment. You don't want to be tied up with resources and costs in lengthy, costly, time-consuming arbitration or dispute processes. So you want to avoid the dispute first and foremost. And secondly, if the dispute absolutely cannot be avoided, you want a rapid resolution to the dispute. And that's what DABs do in essence. Sebastian set out the constraints, that effectively legal constraints. I won't go through it. This is word for word, more or less what he set out in terms of jurisdiction, spanning jurisdiction, scope of service, procedure rules, and privity of contract. He also pointed to potential routes for resolution or to overcome these challenges. He spoke about multi-party arbitration, multi-party adjudication, models from the ICC or the LCIA. So there is a degree of precedent there in terms of joinder for these proceedings, and it's something that could be worked on. So the idea that I want to leave with you today, and I'm going to give some examples of how this might work, is that, you know, I think we're all agreed that there's a need for bespoke DAB provisions for offshore wind. All dispute board clauses across multiple contracts for the delivery of a particular project need to be aligned when you've got multiple contracts and multiple suppliers. Some precedent exists in terms of multi-party arbitration and adjudication, and again, the ICC or LCA wording could be used as a reasonable basis for starting. I want to look briefly now at some existing models or hybrid models of DABs that could form a useful template or a useful guidance in terms of what could be adopted for offshore wind projects. Going back to the London Olympics in 2012, they had two panels. So it's a massive project and an absolutely fixed deadline. You know, you couldn't extend the deadline for the Olympics. They had to start in August 2012. Huge budget. So they had two panels. One, an independent dispute avoidance panel comprising 11 members, including a chairman. They were designated upon joint request. They had great flexibility in terms of the process, and they held regular meetings. So that was the dispute avoidance dimension, which for the most part dealt with the disputes and avoided disputes. Where a dispute could not be avoided, it was referred to the second panel, again, comprising 12 members, including the chairman, and it followed the UK statutory adjudication rule, so rapid resolution of disputes. The reason they had two panels in the UK is there's a concern around jurisdiction. There's some case law in the UK whereby an adjudicator under the statutory process, not at the Olympics separately, was asked to mediate during the adjudication process. He did so, the mediation failed. He did an adjudicator's decision and it wasn't enforced. So there's some case law around that. So there's concern in the UK around that. How real that concern actually is debatable at the moment. But in any event, they had two panels. The outcome at the London Olympics really was that the project was completed ahead of time and within budget. There were a small number of adjudications or court referrals for enforcement, not a huge amount. It was really a hybrid form of DAB for multiple large-scale projects, and was generally considered successful. There's more information on each of these examples, and I'll give you the link at the end of the presentation. The next one is the ITER project in France. This is a huge project that's going on for a lot, 15, 20 years is ongoing. It's a nuclear fusion research mega project in the south of France. There's 6-member adjudication panel established, effectively a DAB. They operate on 5 to 7 year terms apart from the chairman. There are multiple contracts in force, multiple interfaces, and multiple technologies and new technologies in play. So ripe for dispute flashpoints. Use the FIDIC red or FIDIC yellow books. Interestingly, the project owner, Fusion for Energy, the adjudicators are employed and imposed on the contracting of parties by Fusion for Energy. So you don't have a choice. If you're a contracting party, you have to accept the adjudication panel and the imposition of the DAB. The DAB themselves then generally follow the typical DAB process, site visits every 4 months, presentations, engagements, and meetings. So really trying to avoid disputes, given formal opinions, deal with issues that they come up, typical dispute avoidance mechanism. Where a formal dispute is referred to the chairman. He selects a panel from his adjudication panel, and that panel then is obliged to issue a decision within 25 days. So again, you've cross-pollination, cross contract effects of your DAB, and really the outcome, it allows multiple and interlinked disputes to be dealt with. The process, the project, I guess, is ongoing and deemed to be successful. Final example then is the CERN project again in France, again a mega project, a high luminosity project. Basically, the Large Hadron Collider comprises of a 27-kilometer circumference tunnel, 175 meters deep, across the 2 jurisdictions, France and Switzerland, up in the mountains. So 2 projects, 2 designers, 2 contractors, 2 contracts, different ground conditions and jurisdictions, using the FIDIC red book. What has happened here is there's been a 5-person DAB appointed. Interestingly, during both the design and the construction stage, so the DAB was involved in the design stage, which is a really useful mechanism or tool, I believe, in terms of potential interface issues, where you can deal with them up front and at an early stage in a project. The DAB in that's a situation at the CERN project, really do give informal opinions and make effective use of non-binding opinions. So the outcome again there is allows multiple interlinked disputes to be dealt with. And again, the project is ongoing and deemed successful. So there's just a number of examples of existing models or hybrid DABs that work, that have been in operation for some time, that have proven largely successful, and could form the basis of a model for offshore wind multi-contract DABs in due course. A couple of common themes there. There are larger DABs, there are larger panels, it could be 7 to 12 member panels from which you could choose, due to the extent, the size and nature and scale of the projects, and the multiplicity of contracts that are involved. The panels are generally in situ for 5 to 7 years, so good knowledge is built up over that period, so they can hit the ground running when an issue arises. Chairman, very, very important, makes the appointments across multiple projects, and we've seen the Fusion for Energy with the ITER project that it's imposed upon the contracting parties. You don't have a choice on who you get. So that's one way around it. So there are some common themes. So just a thought I want to leave you with, really, and we're open to questions and comments after this, once I hand back to Nick and Georgiana. I mean, multiple contract DAB provisions, I think the panelists believe are very, very necessary. They're not without their own challenges. They're not without constraints. Are they constraints that can be overcome? Yes, I think we're firmly believe that they can. Do we need to do some more work in this area? Yes, absolutely we do. And the thought I want to leave you with is, the DRBF, in consultation with the World WFO, the World Forum for Offshore Wind, and other interested stakeholders, FIDIC could be a typical example. In consultation, might consider the appropriate wording and provisions of multi-party DABs. So drafting procedures, drafting clauses, drafting arrangements that could be adopted, because I think they're very, very necessary. So that's it for me, really. I mentioned earlier that the existing models and hybrids that I spoke about, the information was, I lifted it more or less fully from an earlier presentation, DRBF presentation in The Hague in December 2022. presentation given by Mr. Murray Arms, dispute boards for nuclear projects, a DAB member's perspective. And the links, you get the slides at the end, but the links to the publications library on the DRBF website are all there. So with that, I'd hand back to Nick, and thank you for your attention. I'm available to answer any questions as required. So Nick or Georgiana, back to you.
Thanks, Gerard. Yeah, and as Gerard said, and in fact most of the other speakers said as well, if you've got any questions, please post them in the Q&A. If you would like to ask your question yourself, then indicate that, or if you prefer that I read out your question, then that option is available as well. And also, as Gerard pointed out, the slides and a recording of this webinar will be available on the DRBF website within the next few days. But let me kick off with a quick question for Sebastian. Do you think that it's more difficult to draft the appropriate contract wording or to convince parties to sign up to that wording?
I think the last one is more difficult, because the parties are frequently not really much persuaded and convinced that this is a good idea for various reasons. I think it's not as difficult to look at everything if you know, or at least if you have tackled everything, which I, of course, I'm not pretending to have tackled, but it is, I think, the bigger problem to convince the parties.
Thanks, Sebastian. Now we've heard a lot of good stuff today. I hope generally with an optimistic theme, but certainly the challenges have been set out as well. So a question to Nicoletta, if I could first of all, should the multi-contract nature of offshore wind be seen as encouraging or discouraging dispute avoidance and adjudication boards?
Nick, I'm a lawyer, and so what other answer you expect from me then? It depends. I would say, as I try to transport in my presentation, it always depends on the situation, on the possible disputes which may arise, etc., etc. But in general, I would say yes, at least in the phase where time is of the essence and where there is a need to avoid big delays, etc. It is at least always a try, an attempt to have a dispute board proceeding and to either even avoid bigger disagreements or at least find a preliminary solution in a very short period of time, so that there is no, or at least a minimized delay to the project, so that the project can go on. And if there remains a disagreement, that this disagreement is decided later on when time is not as much of the essence as, for example, in the execution phase.
Good, thank you. And Sebastian, would you like to come in?
Yeah, I would like to ask Nicoletta, on top of that, would it make a difference for you to consider that it is, if you have to consider that it is a standing DAB or an ad hoc DAB? Because, yeah, just a question probably.
Yes, good question. There are pros and cons to standing DABs, according to my opinion, as well. A standing DAB is certainly faster and can interfere and facilitate the situation earlier. So it may step in to avoid disputes. This is definitely a pro. However, this is probably worthwhile only in huge multi-party contracts, because you know that all employers, contractors, etc., always have the figures and costs involved with standing dispute boards in mind. And therefore, I think many decisions against the standing board are taken because of the costs accompanied by a standing DEB.
Thanks.
Even though it's proven that the actual cost of the DB is a small fraction of the project management cost, and is actually leading to a huge saving during the project. Nick?
Yeah, no, well, Gerard, would you like to come in?
No, thanks, Nick. I was going to make a similar comment to what Georgiana just said. I mean, it's, you know, standing DAB, it's a cost. It's really a form of insurance, really to avoid disputes. I've seen it in action myself. The dispute avoidance dimension really does work if you got a kind of engaged dispute board and parties that want to work with it. So it's a cost, but it's a savings. It's an investment, I would say, or form of insurance. And that's my practical experience from working as a dispute board member. Nicoletta, thanks, Nick.
Thanks. And now a question for Tobias or Marcia. Is the with the development of floating offshore wind, is that going to make the demands on port facilities even greater than we have seen to date?
Of course. So, very good question, Nick. So, a floating facility has much more need of space compared to a conventional monopile foundation. So it's ridiculously large, to be honest. So several soccer fields that you need just for one facility there. And that will, so the port facilities are searched after like gold already now. Yeah? So the very short availability of that, and that will be put under pressure much more by the floating market. That will lead that you have now this setup, and Marcia and myself, we choose it because of this, yeah, as I said, very down in the food chain, but this will be even split up then on several sites, maybe by the same operator handling here on the several contracts. And you have to imagine it's the same company below here, the terminal, with different contracts. So care and custody is here under this contract. It moves on to the same people, care and custody, but on a different contract. So something happening here might be an obstruction under this other contract, which you should deal with. And then maybe it's even on a different side in floating. So to have help there by somebody external, also calming down people in this heated up situation, handover, and such simple things as Marcia addressed it, unleashing. So you might have an inspection with the stuff tied onto the barge. You unleash sea fastening. It's stuff, huge stuff that might have covered something. Yeah? So it's, you can go to very detail in all these procedures with a lot of surprises, and with floating installations being much more complex, that will be an interesting development. And I would recommend everybody to have somebody on speed dial to come over, help the people avoid disputes.
Thank you, Tobias. Okay, well, we've no more questions, but I'd like to ask each panelist just to make a few closing remarks, few sentences all. So Nicoletta will go in the sequence in which everybody spoke. So Nicoletta, would you like to make any closing remarks?
I think a lot has been discussed already. It was also for me a very interesting discussion. The time was actually too short to discuss in detail, unfortunately, and yeah, very interesting questions will come up with regard to the rules for dispute board proceedings, and also with regard to the new technologies in offshore wind. So looking forward to many more interesting questions and situations. Thank you for having me.
No worries. Marcia.
You're mute, Martha.
My takeaway here would be, or actually my last final remarks would actually point out two experiences shared with Nicoletta, that standing DAB costs, and then going back actually to Sebastian's question, may pay themselves up because DAB proceedings do not become necessary because all the parties are sent parties and want to cooperate, rather the opposite. And some of them actually may try to use the procedure or may try to use the circumstances to dodge it out. So by adopting by undertaking this cost, which can actually be managed between the parties, you end up avoiding a huge other load of costs ahead in times where it will be actually key to have agility. And thank you very much for having me. Appreciated the opportunity.
No worry. Tobias?
Yeah, just for comparison, just this week I had the invoice for 55 million premium invoice on a construction or risk insurance for a 2.5 billion project. Everybody said, oh yeah, that's a burden, that's quite a number, but it's the usual thing if you want to cover everybody down to the last welding workshop in the project, was a fine thing because you're insured, you eliminate risk, you handle it by deductibles, all fine, all recognized in the industry. To have somebody retain on speed dial to solve your problems is a fraction of those costs. Nobody should think twice if to do it or not. And in our industry, as you see it, as it develops, there's no kind of white knight showing up offering EPC service for each and everything. It will be more fragmented, even more. You will deal with multi-contracts much more than ever expected. And it will give a push for that topic, as my fellow panelists addressed it here so nicely. So I join them. Thank you in having us here also from the WFO. Thanks.
Sebastian, please.
Yes, thank you very much, Nick. I do really think that we have been able to demonstrate that it is worth to think about DABs and hopefully also about standing DABs, because particularly in these multi-party scenarios, it is really helpful to avoid extra costs, because if you just think at the extra cost which you have in each contract for dispute resolution, which you could have avoided by one single DAB, which isn't present and may come to the site looking at everything from a different angle sometimes, but looking at everything, having already the up-to-date knowledge from the site. That's something I think which is really valuable, and the little constraints which I've tried to outline are nothing really in comparison to what is the benefit. Thanks.
Okay. And over to Gerard.
Thank you, Nick, and thank you to all my fellow panelists, which was an excellent webinar. I mean, I just want to finish by saying, you know, the need for a DAB is clear. You can hear from Tobias in particular, who's at the code base day in, day out. There are challenges and constraints that we've heard in terms of multi-contract DABs. And fortune favors the brave. I'm fully confident that we could overcome the challenges and the constraints. We, as a DRBF and the WFO, and those of us who are interested in this area, need to overcome the challenges because they're needed, and we will overcome it. I'm confident of that. I just want to finish by thanking Georgiana in particular for chairing the session, and to congratulate her and embarrass her slightly for becoming the president-elect of the DRBF. So well done, Georgiana. Thank you for all the work you do. Thank you, Nick.
Thank you very much, Jerry. Thank you very much, Nick, and everybody for joining us today, in particular to our panelists who have done quite a bit of effort behind the scenes to put it together and try to give you everything into a nutshell. We will have 2 more events in this series for the 2023. So please check the calendar on the DRBF website. One is going to be in September and one in November. But until then, I invite you next week to Sao Paulo to the annual conference of DRBF. And if you cannot make it then, July in Kenya and October in Istanbul for the MENA region. Thank you very much and see you next time.
Thanks all.
Thanks, everybody.
Thanks,
Goodbye.
bye-bye.
Thank you.
Good luck.
Bye-bye.
See you.